Hey everyone, welcome to another episode of Darshan Talks. I'm your host, Darshan Kulkarni. It's my mission to help you trust the products you depend on. And as part of that, it's actually trusting that your privacy is safe and ensuring that appropriate steps are taken to make sure that the products you receive, the services you receive, don't compromise you in any significant way. So if you are interested in anything associated with the life sciences, if you're interested in just business to business disputes, today's conversation is going to be really kind of interesting. If you think about, as you know, I'm an attorney and I advise companies with FDA regulated products. So if you think about drugs, wonder about devices, ponder over pharmacy, this is the podcast for you. Again, both of us are attorneys. My guest today and I are also are attorneys. So do have to clarify, this is not intended to be legal advice. I'm a pharmacist as well, so it's not intended to be clinical advice either. So that's one of the key pieces. I do these podcasts because they're a lot of fun. I like to ensure that everyone's sort of enjoying themselves. So if you are, please like, share, and leave a comment, and please subscribe. Love to have you be part of this community. You can always reach me on Twitter at Darshan Talks, or you can also reach out to me on my website, darshantalks.com. Our guest today is an attorney at Flaster Greenberg. She is the go-to privacy guru at Flaster. So we're going to find a lot more. We're going to discuss a lot about what that means and what that looks like. So stay tuned. This is going to be really, really exciting. Our guest for today is Krishna Jani. How are you, Krishna?
Hey, Darshan. Thanks for having me. I'm well. How are you?
Okay. I'm doing well. Thank you for coming on. Tell me a little bit more about what your role is at Flaster. What have you been working on and how have things been?
Yeah, things have been really good. I'm in our Conchi office today. Usually I'm in Philly, so I sort of have the benefit of going back and forth. Things at Flaster are great. We are a full service firm, for anyone who doesn't know. We are a regional firm here in the Philadelphia region. So we've got offices in Conshohocken, New Jersey, New York, even now Florida. And we're full service, which is great because as a privacy attorney, I find that my practice area overlaps with a ton of other practice areas that of course have to take privacy and security into consideration in building out structures and launching websites and the like. So I've done some of that recently, lots of privacy policies and sort of compliance and counseling on folks who are launching consumer-facing products and launching websites for that. We're also handling some pretty big litigation for companies that are engaged in business-to-business disputes, as you mentioned, regarding the development of software technologies. I think we mentioned this a little bit before we went live here, but I'm also working with another software developer who used to sell sort of CDs, old school CDs. Think of like, my generation, we played Carmen Sandiego on CD-ROM. So he would sell software that way to medical providers, and of course, when we talk about any medical information, we're dealing with protected health information or PHI, and now he's migrating or moving to a cloud-based system. So we're helping him with that update.
Well, so there's so much here that we need to get into. Let me start with some of the basic questions.
Sure.
You mentioned that you work on developing the privacy policies for websites. That's one of the things you threw out there. I get these questions all the time where I'll have someone reach out to me going, you know what, I'm developing a website for my company. Can you help create a privacy policy? And it's a minor thing. Don't worry too much about it. Don't spend more than a half hour to an hour working on it, because we can just sort of copy it from another website and put it up here. What is your response when you get that question?
Oh my God, Darshan, that is something we get, depending on the size of the company and who we're dealing with and their level of knowledge about privacy and security. We get that a fair amount too. And what I try to tell people is that, look, not only is the law moving in the direction of being more privacy conscious and understand that data is a commodity, that people in theory have a right to access, control, and the idea is to be transparent when you can. And so I try to caution people against slapping a boilerplate privacy policy on their website, depending on what they do and this level of sophistication of their company, and really building out a privacy policy so that their employees and their vendors are bound by that policy, so that they are putting a notice on the website that is both current, that stays updated, and that reflects policies that both inform consumers or the data subjects of their rights, and let them know as data controllers or processors what they do with their data. So I really try to create sort of this like dialogue and symbiotic conversation about this, and letting them know that if they do want to take the easy route, that's okay, but that's something that we sort of caution against because they're going to have to revisit it and revamp it down the line anyway.
So you talk about the movement towards more control, the movement towards patients and subjects and consumers having access to that, and being, as you put it, data controllers, if you will, as companies. I guess my question for you is, a lot of these startups haven't even, they're still working on what their idea is. To start thinking about processing data is an afterthought. It's almost like how they're going to make money, but do we need to worry about that right now? Do you advise startups to get into that space and start sort of get their hands dirty early on, or do you sort of do a phase wise? Here's where you are right now. Work through this component, and then talk to me about this component. How do you sort of advise companies?
Yeah, no, that's a great question. And I think, again, I mean, I don't want to be like a typical lawyer and say it depends.
Of course.
But it depends to some degree on what the company is and what they're aiming to do with that data. So if they're selling data for profit, there's a whole nother set, especially when taking into account California's CCPA and especially the new, not yet in effect, but newly passed law, the CPRA. There are all sorts of implications on companies that sell data for profit, or to earn revenue, I should say. But if you're not doing that and you're just using data for whatever, for data analytics, for example, or to process financial information, all that is important because what I caution against is just sort of slapping a policy and like not taking data into account and then trying to filter it in later, because it doesn't work that way. Data is part and parcel of everything we do, especially when we're working online and we're collecting everything from name, address, email address, financial information, in some cases when it comes to things like telehealth, protected health information. So building a privacy by design policy from the ground up is, I think, more effective and even more cost effective, arguably, in the long term. And of course, like attorneys, we always think about risk. You want to mitigate your risk. That's something, if a breach happens, right? If a cyber attack happens and it results in a breach, you are protected to some degree, depending. If you've taken this into account, built it in, and you're doing the right stuff from the ground up.
So I mean, that's super important, and sort of like you said, it goes to risk mitigation and prioritization and all those good things. But let's say we've got a company now that's a little bit more developed. They've got their feet underneath them, and they're going, okay, I need to start thinking about a privacy policy and how that connects. How do you guide them?
Yeah, that's great. So I would start with a series of questions. You know, what does the company do? How does it collect data, and from whom? Because another consideration is, you know, you have these sort of categories of data. You've got financial data, you've got protected health information. Some of these things are governed by federal statute. But when you're coming to sort of different levels of data, apart from like subject matter categories, you're getting into how old is this person? You know, if you're talking about the data of minors, you have to be careful about how you treat that, especially if they're under the age of 13, pursuant to a different federal statute. So all that matters in terms of collection and storage. And then the idea is to figure out, to map that data, right? Where it goes in the systems, who has access to that data. We really try to emphasize data minimization principles, which means only collect the data you need for the purpose of your business, and don't store it for longer than you need. You know, if you've got someone you've not spoken to or who's no longer a customer or patient, there are some laws that govern how long you've got to keep that information, but generally don't keep it, right? Because stale data is a liability. So we sort of start by asking a series of questions and then go through the types of data, map that data, and then employ a series of policies and thus notices to the public or to the patients about those policies, so that, again, it's transparent and consistent across the board.
So, which is really, really interesting. So you talk about this principle of data minimization, which is super interesting. It sort of came out more, I think at least, from GDPR, and that was where it really started. But there's a whole element, and it's not just a privacy data at this point. I'm talking about data in general. In the life sciences, one of the big things we struggle with is this idea that more data is good data, because then I can connect and draw connections I didn't even know about. So my question for you is, how do you argue with the logic that, yeah, maybe more data is good data because you can draw correlations that you couldn't see before?
Yeah, that's a great question, especially taking into account the field that we're talking about, which is life sciences. So you're talking about things like, I think it's all our minds right now is clinical trials, vaccine research, and research and development generally in the scientific field. So I'd answer your question by giving you a caveat. It depends on what type of data and how it's stored. So if you've got personally identifiable information or protected health information, again, that's a huge liability. You can do it, but you've got to do it in certain ways and make sure you've got the right structures in place and security in place. But what would be more important for your business probably is just having the data and not having it be connected to a data subject or an individual, which means that you can pseudonymize it, or probably better is de-identify it. And I know that this is the GDPR provides exceptions for, among other laws. They, if you have data that's de-identified, meaning that it can't be connected to a single person, then the risk of having that data and thus having unauthorized access to that data greatly diminishes.
So we're talking about these two terms, and they get thrown around a lot. Could you help explain what de-identification is, and how does that compare to pseudo-anonymization?
Yeah, so pseudonymization is it's just a lesser level of protection because it think of a pseudonym, right? You're assigning something to a set of data that is not the actual person's name, or perhaps not linked to all facets of their data ID, or digital ID, we should say. But it's not as robust in terms of protection as de-identified data, which removes several more factors and really strips the data of, to the extent practicable and possible in some cases, of linking to an individual person. So let's say someone finds out that patient A has some disease that may have a stigma around it. It's important that that data is de-identified for the purposes of clinical trials or performing research, because we don't need to know who patient A is. We need to know what the data yields, what the research yields, rather. So in that case, I think it can be important for researchers, developers, hospitals in some cases, to keep data, even more data than they may need perhaps, or a greater set of data than another type of industry might need. But for the medical field, you might need more data. But the idea is if you store it and de-identify it, then it subjects the company to less liability if there is unauthorized access. And I think that is something to consider across industry.
I think that's a really important point, isn't it? This idea of unauthorized access. But when I talk to clients, they all know the importance of data privacy, and they know the importance of protecting patient information. But there's a certain sense of fatalism that I sense when I talk to them, which is, if I'm going to get hacked, I'm going to get hacked. I'm not sure how much more I can do. I have an entire IT team, but it gets past them. What am I going to do? So why bother going above and beyond if there's there's that sense of fatalism? I just heard that there's a whole a local hospital that you and I have probably been around. I don't want to name names because I don't know if it's in the news yet. Recently got hacked, and the truth is most hospitals are getting hacked, and that's a big issue. I guess my question to you is, how do you help convince companies that yes, there may be a sense of fatalism around it, but the fact is that you still need to take those steps?
Yeah, and I think that's where having the sort of backing of my full service firm comes into play. We've got corporate folks, we've got litigation folks. I work a lot in litigation. So putting my litigator hat on for a moment, when I'm looking at these cyber attacks that result in breaches, especially when when it relates to protected health information, I'm not just thinking about, okay, sure, there might be a cyber attack on your organization. I'm thinking, okay, what is someone going to sue you as a result of that? And if they do sue you, what is your defense going to be? Is your defense going to be, we outsourced our IT and we have no consistent contact with them. Our privacy policy is 5 years old. Our systems have not been updated. Our hardware and our software is outdated. And by the way, we've never talked about cybersecurity at a single board meeting. That might be a significant problem when it comes to finding liability for having done that. So I think a sense of fatalism for experiencing an attack is one thing. A sense of fatalism that could actually pose an existential crisis to your organization is a completely different thing. And I think, having those discussions, putting systems in place, making sure your vendor agreements are up to date, making sure your privacy policy is up to date, making sure your software is up to date, all of those things can be factors that courts or regulatory agencies take into account in assessing penalties, fines, and other violations. So, and to some degree, I want to be sensitive to clients or hospitals or medical providers that are small or that are startups or that are just maybe, it's a business decision. So to some degree, if you want to make a business decision that you understand could subject you to more liability if you don't sort of update that when you've got the funds and the time, that's fine. But my job is to let people know what the risks are if they don't do that either now or in the, pretty soon in the future.
It's interesting. I always think about that word business decisions because I find the concept fascinating. And what I mean by that is you're right. We all take this position that, yes, you can spend the money on it, or maybe we should spend it later on. But as a lawyer, I always think it's my job to tell you the risk. You can make the decision you want.
Right.
At what point have you sort of found this idea that they now have something written down that says this is a risk, and they're going to now ignore it? And so how do you handle that part of it?
That can be difficult. I will say that I have not had the experience yet of a client experiencing. Well, I had one potential client come to us and have a discussion about, and this is not in life sciences, but he's an attorney. His firm was hacked, and he had no idea when the hack started. He had no idea when it definitively ended. He did not know what data had been accessed and what was done with that data, but his payment, I think a payment coming to his firm from another firm from a settlement, had been intercepted, which is how they discovered the cyber attack in the first place. And he was very concerned about getting that money back, but not concerned with the rest. And so we kept trying to tell him, well, look, that's huge. This lump sum payment that goes to your client, that goes to your firm, absolutely important. But also getting a hold of the scope of this attack is paramount to your very existence as an organization. So let's talk about that. And he just was not interested. And so for a lot of reasons, it sort of didn't work out in terms of representation, but that can be difficult. It's a fine line. It depends on the organization and what their resources are. And sometimes what their level of understanding is about the repercussions. The law is just starting to take shape. It does not follow the same pace as technology, of course, cyber attacks and other sorts of innovation in the sciences. And so that sometimes is difficult to manage. People who are not so well versed in the law, but may have a really robust sense of the science, and you sort of have to say, well, the law's catching up, but also if it gets to this point, you're in real trouble.
I love what you're getting into, but let me ask you a question that you sort of hinted at when you talked about technology changing. It sort of reminded me of something, and I'm fully aware you may not have dealt with the issue. So if you haven't, feel free to say, I haven't dealt with this issue yet. But when we think about technology, I think recently about blockchain.
Sure.
And the big thing with blockchain is it is immutable. That's the whole point of it. And yet everyone I know is talking about putting things onto the blockchain, including patient information. How do you advise? Now, first of all, are you aware of either an exception or a methodology? And again, there may be other methods, but have they come across your table yet? Where you can sort of address and help and work with blockchain and still be in compliance with GDPR, CCP, or something else?
Sure. I will say that I personally have not dealt a lot with blockchain. But for example, I mentioned at the outset that I was talking with a software developer who was moving to the cloud, right? So he's moving to the cloud system. There's going to be communication available. There's going to be storage and also sort of interactive platforms available. And he told me sort of look, I don't think I'm going to use encryption for XYZ. And I said, wait a second, guy, you're dealing with protected health information. You are building out this from scratch. You really want to consider using end-to-end encryption for all of your communication to the extent you're talking about protected health information and patient data generally. And there was a little bit of pushback. And again, he's a software developer. He understands the industry he's in. He sort of created this from the ground up, his business. So it's not a blockchain story, but the idea is I am very risk averse. I will sort of always recommend this high level of protection, of the highest level of encryption in transit and at rest, because it's the greatest level of protection you can get. And if in your business judgment you decide not to do that, that's fine. But depending on the type of data, not so much with HIPAA and high tech, but the idea is I just try to caution them against any lower level of protection. And if they do it, it can be okay.
Right. So let me ask you another question. And I've wondered about this for a while, which is this idea of, and I'm sorry, I'm going back to the conversation we had a little earlier around anonymization and pseudo-anonymization. And one of the questions we've dealt with, and I'm sure this has come across your table before, is this idea that there's no such thing as anonymization anymore. So how do you deal with that concept when you're advising companies?
Yeah.
So I'll let you sort of expound on that a little bit.
Yeah, it's so interesting. I wish I had the book in front of me. I was reading a book. I think it was the one written by April Falcon Doss. It's the new one that she's just put out, and it's all about cybersecurity and privacy. And she cites a study. I think it was performed in the 80s or 90s. So technologically, decades, eons ago. And it talks about how at that time, anonymization of data was becoming so obsolete that even with 2 or 3 data points, they were able to tie a data set with an actual individual person, which is startling. What I would say is, to the extent you can de-identify and delete information that relates to an actual patient or subject or person, because it doesn't matter for the purposes of a clinical trial or other sorts of research and development, I would advise to do it. Because again, when you're talking about, from my perspective as an attorney, when you're talking from the perspective of a litigator, you're thinking, okay, so have you made the effort? Like, what is the standard legally? And then have you followed that standard to the best of your ability, even if it's impractical given the sophistication of cyber attacks these days? Have you done it to the best of your ability? That's what I would say. It's not, no system is perfect, and so I think that the knowledge of the law and the standards in your industry and the attempt to comply with those laws is what's going to be taken into account if and when this ends up in before a regulatory agency or in court.
So let's take a little bit of a pivot and go into some of the things you've talked about. And I don't want to dig too deep because you talked about some fascinating things. But the one that really struck my interest, I mean, there were 2 that struck, well, actually all of them struck my interest. But the one that really spoke to me was this idea of the Uniform Personal Data Protection Act. And we talked about that a little bit before the conversation started. Can you talk to us a little bit about what that is? What are the implications of it? And quite bluntly, why should I care?
Yeah, let me tell you what it is and why you should care. So the Uniform Personal Data Protection Act was proposed by the Uniform Law Commission. This is the organization that put forth the Uniform Commercial Code for any attorneys out there. It is basically a model bill. And what it does, and this is important, you should care because they spent at least 2 years. I think this project was started sometime around 2019 with the Uniform Law Commission, or the ULC, as I'll call them. And I wrote a blog piece about this today. So if anyone wants more information and sort of more in depth and a link to the actual adopted UPDPA, feel free to check out my friend bio where the article is. But basically, this is important because it provides a model bill for states to adopt privacy legislation. And this is something that states have struggled with for many, many years. And as we all know, our federal government has struggled passing any federal data privacy protection. So in the absence of comprehensive federal legislation that deals with data privacy, states are, as we know, in California, Colorado, Virginia, are all adopting laws on the state level. So that can be great because that means, from an individual consumer's perspective, they've got more protection. From a business perspective, they've got actual words, laws to comply with. Whereas it was sort of, here's the best practice, but there's no mandate. So as an attorney, it was sometimes hard to guide folks in the right direction. This is essentially going to be something that can be just shown to state legislatures so that they can take this law and adopt it as it's written and pass it into law that is binding among for businesses who do business in that state, and or can be modified according to the needs of that state. But it sort of takes all the guesswork and all the grunt work out of crafting a piece of legislation from scratch. And I know I'm going on about this, but I've been tracking state legislation for the thing, which is that when we look at laws like California's, Virginia's, even Colorado's to some extent, this is a law that is actually it does not confer as many rights upon the data subject, meaning, with the GDPR, we've got really stringent laws with regard to the data subject has a right to request erasure or deletion of their information if they no longer be part of a given organization, system, or data storage collection. This model bill contains no such right. That doesn't mean companies shouldn't or can't do it. It just means that it provides for somewhat different rights. And interestingly, as it relates to the life sciences, it does categorize, and I took some notes on this so I don't sort of misspeak here, but it does categorize diagnosis or treatment for health condition and genetic sequencing information as part of its definition of sensitive data. And sensitive data under this model bill, again, it's not law yet, is treated differently than personal data. So it has implications for the life sciences and sort of across industries.
Well, it's an interesting thing you raise, and I recognize this is brand new. So A, it's never been tested. B, you've not done an analysis on this. But it's funny you mentioned the word medical data. Is it medical data if it's not being used for clinical purposes? And what I mean by that is if you're doing clinical research, yes, the data obviously comes from a person and it has clinical implications for sure. But if it's not being used for the purpose of treatment or curing or mitigating a disease state, because that's not what you do in a clinical research study, is it still considered to be part of that sensitive data, or does it not get the same protections?
Yeah, no, that's a great question. And I think we'll see that as states adopt it and maybe add some caveats to that definition, for the medical data for the purpose of, right, which could be a good clarifier.
Yeah. The interesting, I just saw a thing going up. By the way, we have a lot of people listening, so feel free to jump in with questions and stuff. I already got a couple of questions that I've been trying to hold off, but let me put one out there just so people know that I'm not completely ignoring them. Okay. This one's from Lydia, by the way. Okay. So I missed a moment, so perhaps you address this. Do any new privacy and data laws affect physician mobile networks where life science product marketing messages are targeted to members?
Sorry, the light in my office just went out on me. Speaking of technological, defects. So do any new privacy and data laws affect physician mobile networks where life science marketing messages are targeted to members? I don't know the answer to that off the top of my head. What I will say, again, is if physicians are speaking with their patients over telehealth networks and other such communication platforms where they are discussing things like protected health information or not sensitive data as it's not defined anywhere, but data that relates to a patient's mental or physical health, you do want to take HIPAA and high tech into account and utilizing really robust security encryption methodologies that are suited for that type of practice and that type of communication, and generally understand data minimization principles. So if this does not have to be accessed or, accessible to other folks in your office place, you might want to consider, enacting some walls in between the folks who need access and the folks who don't. And that also can help protect that patient data and confidentiality generally.
Very, very cool. As you know, I usually aim for these to be about 15, 20 minutes. We are already at about double that time. So you are a fascinating conversationalist. I hope you'll consider coming back again. But as you know, we asked 4 questions. So the first question, what is a question you'd like to ask the audience based on what we just discussed?
I guess I'd like to ask the audience what their sense is of data privacy. Do they care? Do they care if they Google something that on their phone a day later that they're getting targeted advertisements for something? Do they care about the robocalls? What is their sense of if their data is being sold, how it impacts them and what they'd want the law to look like? Because that is going to impact greatly, I think, what happens over the next 3 to 4 years, both on the state and federal level.
So I usually try to answer the question first, just so you have a feel for it. I'll tell you that from my perspective, I would love to say that I care so much about privacy, and I probably should, that it's a huge concern in my mind. But if you told me that I need to tell you where I am, or I need to pay $1 to get access to a newspaper article, chances are I'd say just know where I am and I'll move on with my life.
Really? Interesting.
And I don't think that's a smart decision. I just think it's an easier decision. So it goes to the point of, I've had guests on here who talk about nudging behavior. Have you ever heard that term before?
No, I haven't actually.
So nudging behavior is basically how Facebook or Amazon keeps you clicking on their website, how Facebook keeps you clicking on their website. So making certain decisions easier than other decisions.
Right.
So for me, the idea of going onto my website, if someone says either give me $1 or sort of allow for me to see where you are, the allow for me to see where you are button is going to be one click and it's over. Or I need to go in, log into PayPal, make sure I say okay, then see it's only $1, make sure that the $1 is the only thing that went out, come back, and then read the article, and I go, either the article's not that important or it's just not worth that much. Is that the smartest thing in the world? Probably not. In aggregate, I know it adds up to a lot more than they know where I am.
Right.
But at that second, for that decision, the cognitive overload for the second decision is too much. Is that different from what you take?
Sort of. And I don't know if it's because I do this work or it's because I also sort of view privacy the way perhaps Europeans view privacy, which is that it's a fundamental human right. Satya Nadella, the CEO of Microsoft, has said this too. But there's that caveat when you're talking about developing, this is a whole other sphere here, but artificial intelligence and predictive behavior analytics, you don't want to stifle that technological innovation. That can be super helpful for people who, for anybody, frankly. But there is that middle ground that I'd like to strike. So I never let anyone track my geolocation on all my apps. I don't go onto unsecured Wi-Fi networks if I can help it. I mean, I really am pretty cognizant of this, and I think I hope that people are a little bit more mindful about this insofar as it relates to their own personal data protection.
I love it. Here's an answer as well, by the way. I do care about data privacy. I would like to see monetization in the future. However, we need to build in data privacy support for those that don't want to control their data or don't care about monetization. I agree about paying for articles. I will not pay.
Thank you, Christine. That's helpful. And I think a lot of folks feel that way, the way you and Darshan feel, which is that they're not going to go on, create an account, upload their financial information, only to click on an article that they, for a website they may never revisit.
Exactly right.
Right.
But I don't think I'm right about this decision, because like you said, in the end, it is not the smartest thing. Which is why I do think that there's a significant amount of value to something like GDPR and CCPA and data minimization principles. Having said that, I find it really interesting. I need to go back to the UPDPA. I think I got that right. I've written it down. That's the saddest part. But yeah. But I think that's going to be really interesting as we continue to see, as we see this tussle between rights being given and rights being taken away. You see a lot of that, for example, and I know you know this more than I do, but the implication of privacy as it relates to global surveillance, and Europe, for example, has taken the position that we don't want any surveillance, and you will not use artificial intelligence, for example, in the context of global surveillance. On the other hand, China has gone, no, that's the entire point. I'm loving this thing, and then you've got Israel saying, I'll sell you my information because we are a startup nation, and the data we collected for COVID is great for anyone to use. Just come here and use it. Yeah. So it's just different perspectives, and I think it's going to be fascinating as it plays out. But I always wonder if countries that are more cognizant of individual data privacy rights will land up being further behind because the AI simply can't catch up.
That's a really good point. Although we're sort of seeing the opposite in the States in some cases. If you look at the U.S. Privacy Shield, which, of course, based on the European Court of Justice's decision last summer, we are basically, for those of you who don't know, I'm sure all of you listening are really sophisticated and know these things, but for anyone who doesn't, there used to be a data sharing agreement that, with the US and the European Union as a whole. And so any data can be shared across the Atlantic Ocean. It went through many iterations. And so basically it ended up in the US Privacy Shield framework. That was gutted completely. The EU basically said in its decision that the US performs so much surveillance on its own citizens and residents of the states, including European citizens in some cases, who lack a recourse if their fundamental right to privacy has been violated, that the EU does not want that sort of automatic protection or the adequacy decision to stand. And so they revoked that adequacy decision. And so the US companies are having to spend all this extra money to prove to the European Union, pursuant to the GDPR, that they are compliant, that they have to implement these really expensive, in some cases, binding corporate rules or BCRs, or implement standard contractual clauses, or just go ahead and draft their own contracts. There's all sorts of ways this can be done, but it takes that extra effort, and it can be expensive and tedious to go through all this extra hoop jumping just to prove you can get the business and maintain the data in a in a reasonably responsible fashion. So it's playing out in different ways, different places, is what I'm saying.
I agree. Though I have to question now whether UPDPA is going to help address that in some ways. because one of the big concerns they had was you don't even have a national process, a national uniform law. And we obviously that does not, I'm going to start calling it that because it's just simpler. That does not have the impact of a law. It's more of a recommendation. Right. But it's one of those things that UCC has been so successful that if states do tend to adopt it, it's more meaningful than where we are right now. Which one of the questions I did want to ask and I didn't get into was, do you see California and Colorado and Virginia sort of backtrack now, going, wait a second, we've got this. Maybe we should go down this path instead of this other path. So just what's your take on that, just out of curiosity?
Yeah, I don't know. I am now a resident of Pennsylvania, but I used to live in Virginia. And so it was actually a shock. And I think it was a shock to a lot of folks that Virginia just was sort of the next frontier in privacy after California. I didn't expect that. But I know that California, and I won't say I know, I have heard that the author and sort of champion of the CPA and CPRA, Alistair McNair, the goal is to get California as a force, as a really large state, lots of business, its own adequacy decision from the EU, thereby drawing. We're finding it difficult to comply. So I think that's the goal. I don't know if it's not been confirmed. I've not talked to anyone sort of at that level, but I don't think they're going to roll it back because I think that the prevailing law is still globally, the GDPR is the best level of protection, the most robust law. And what I think a lot of folks don't understand is that it's building on decades of privacy law. So this is not new to Europeans. It's not like they're all of a sudden going, wait, we have nothing, and now we've got the GDPR. It's sort of like for decades they've had these protections in place, but they were fragmented in some cases, not as robust as it relates to emerging technologies, for example. And now they've done this. At least, it's sort of like the best thing we've had right now. And the CPRA is a close second. So I don't see them rolling that back anytime soon, but we'll see.
We'll see. Based on what we've discussed so far, let me ask you a question. What is something you've learned over the last month that you'd like to share with the audience?
Something I've learned over the last month. Well, in sort of preparing for this podcast, I was thinking a lot about PHI and sort of when I'm talking to my clients, what's really important. And I learned that in a 2019 report, by a cybersecurity company called Carbon Black, they found that personal health data is 3 times more valuable to hackers than credit card information. And I don't know what your listener senses of this, but when I talk to my clients, a lot of what they're worried about is hacking of financial data. They don't want credit scores to be affected. They don't want theft of personal identity. They don't want, sort of like the things that we think about. I don't think people are thinking as much about their protected health information being a commodity, something like we hear all the time, data is the new oil, but 3 times more valuable than financial information. That's pretty astounding.
That's really interesting to me, especially because I'd heard something on the flip side which suggested that genetic information was not as valuable as I thought it was.
Interesting.
So I mean, I have to go back and find the source, but to me, genetic information seems forever. Like I can't change my genes, sure. but I would imagine that health information, I guess it's constantly updated, so it makes it more valuable. I don't know. Fascinating. Third question: what made you happy this last week?
What made me happy this last week? Let's see. My grandmother had a little bit of a scare, but she is out of the hospital and back home, and it was sort of a false alarm. So I'm happy that she's safe and healthy, and it just made my day that there was, she's getting older, so I'm happy that she's all good. I can't wait to see her again.
That's awesome. Well, congratulations to her, and congratulations to you. And last question, I'm going to put this up as well, but how can people reach you if they have questions?
Sure. So feel free to find me at the link in the screen below, plastergreenberg.com/people-Krishna_Jani, or you can just Google me, Krishna Jani Plaster Greenberg.
Perfect. And this was a lot of fun. Thank you so much for coming on. We have one last comment, by the way, from Christine. You're right. I studied PHI as part of my degree, and we talked about hospital files getting dumped without shredding. And the consensus was that no one would be interested in health information. That seems, I don't know when you studied that, but whoever said that, that's scary when people think that there's no value there.
Yeah, you know what, Christine, that's a really interesting point. Thank you for bringing it up. And Darshan, I know we want to roll here, but please. I just want to add one quick comment, which is that it depends what that protected health information is and what the consequences to the individual are. I'm thinking of really stigmatized, diagnoses, something like
AIDS, I think.
Transmitted disease, exactly, HIV/AIDS. Those are the implications for where someone lives, if they're living in assisted living, if they are in a relationship, a personal relationship that they've not yet told their partner about this diagnosis. All sorts of implications, I think, not only just for privacy, but about where their ability to earn a living and secure housing can be impacted if that information gets out, and if it's not de-identified or in some way pseudonymized. So I think it depends a lot, and of course, best practice is always shred it.
Sure.
Always documentation.
Well, this was a lot of fun, Krishna. I'm so glad you came on. Thank you for coming on, and we hope to have you back soon.
Thank you so much. I'd love to come back.